Workers' compensation is an area of law that applies to situations where an employee has been injured while on the job and provides a specific type of legal remedy for those types of injuries and a process specific to workers' comp cases that differs from and is a little less formal than the normal litigation process we use when bringing claims against others that we say owe us money. It also applies to an exception to the at-will employment doctrine that we discussed earlier, the public policy exception. Workers' comp provides statutory rights to employees, guaranteeing them the ability to pursue recovery for alleged on-the-job injuries. Thus, it would be a violation of public policy for an employer to take adverse action against an employee who's merely exercising those rights guaranteed under a statute, and would therefore fall under the public policy exception to at-will employment, which again is the general rule that says otherwise you can be fired as an employee for any reason. So now let's get into the specifics of how these cases work. First off, workers' comp statutes were designed to make this process of handling on-the-job injuries easier for both the employee and the employer. And there's some compromises on the part of both, but as a result of these statutes, we have an easier way to go about handling these. And like I said, a way that's a little less formal than the typical litigation process. One of the ways this makes it easier on both parties is that workers' comp insurance is no-fault insurance, which means it simply covers a specific type of situation without regard to whether anyone was at fault under normal legal analysis like negligence analysis, or who was at fault, whether it was the employee had done something wrong, if they were negligent in handling something at work that caused the injury, or it was because of the employer's negligence. We don't really have to consider that in workers' comp cases where a employee is covered by workers' comp insurance. The question really only is, did the injury happen on the job, in that it was during the normal course and scope of employment. So that's going to be one of the main issues that would need to be litigated, not whether someone was at fault, but whether they were actually, the injury occurred during the course and scope of employment. And this is somewhat similar to a vicarious liability analysis that we discussed earlier, where I said typically if an employee causes injury to others while they're on the job, the employer is vicariously liable for that because it happened while they're on the job. But they're not liable for it if it happened outside the course and scope of employment, because the employee was engaged in a so-called frolic and detour, in that, for instance, they took the company car while they were clocked in, but they took it to another town to go do something for their own amusement, and that's when the injury occurred to somebody else, or in the workers' comp case, that's when they got injured. So that's probably the main thing you're going to be litigating, because we're not, we don't have to argue about who's at fault, because this is, again, no-fault insurance. Now, every state has their own workers' comp statute that tells you precisely how the mechanics of the system work. Usually there's a some sort of threshold by which all employers have to buy into workers' comp insurance. In South Carolina, I think it kicks in when you have at least 4 employees. I don't know what it is in every other state, but I think it's something similar. There's a pretty minimum threshold that you have to meet before you have to buy into workers' comp insurance. And of course, because this is no-fault insurance, back to what makes this easier on both parties, we don't have to argue about fault, and so that just gives us less that needs to be litigated, and thus less money that needs to be spent, and less hassle that's spent in the litigation process. The trade-off, though, is that because it is no fault, it's easier for the employee to recover money for their injuries, but the workers' comp statutes fairly precisely define what you're limited to in terms of how much money you can recover for what types of injuries. And also, if it's an on-the-job injury, if workers' comp covers it, then that is the exclusive remedy generally for recovering those for those sorts of damages. So it keeps you away as an employee from a jury where you might try to seek sympathetic damages for your emotional suffering or punitive damages against the employer. Now, if the employer did something to you intentionally, that's different. But situations where maybe the employer's just negligence contributed to your injury, we don't have to argue about whether they were negligent. It's just a swifter recovery in this way. And also the process happens outside of a typical courtroom. It happens in front of an administrative hearing officer, basically. So the litigation process as a whole is less formal and just makes it a little bit easier all the way around. Now, of course, for the employer, the trade-off is that they've got to keep this insurance all the time once they meet that threshold, even if no injuries occur, because, say, the employer runs a very safe workplace. But when one does occur, especially when it's a very serious one, like somebody gets a limb amputated, they've already paid into that system, so it helps employers kind of predict the overall cost of covering these things, and you're not going to end up, in most cases, with some wild jury verdict that ends up bankrupting the company because you're covered by insurance that deals with and kind of caps injuries based on the category of injury. So you see in the statutes some of the benefit category benefits there. You have, of course, some people die on the job, and there's it's addressed how that's handled and how much money you can recover for that. But again, it's capped, so whatever you recover under workers' comp, you can't bring any further case to get a jury to give you more money. There's total disability, where the injury is such that you'll never, you're still alive, but you'll never be able to work again. Permanent partial disability, you've got some permanent disability that keeps you from doing certain types of jobs, but maybe there's others you can do. Temporary partial, and so on. You can see there how, in addition to medical expenses, there'll be times when, of course, you're taken out of work to recover, and you'll be limited to a fraction of your wages. That, again, though, are pretty much guaranteed, because this, again, is no-fault insurance, and so it's a lot easier to go about recovering because there's not as much to argue about. Now, insurance premiums, of course, are tied to the employer's record of making claims, like any other insurance insurance scheme. The more, with your auto insurance, the more claims you have to make against it. Obviously, that's going to affect how much your premiums cost. And, of course, the number of employees, perhaps the type of work. And so for this reason, sometimes employers, and this is why I mentioned the public policy exception to at-will employment, employers can get kind of agitated by these, especially if it's the same employee who gets injured quite frequently, and the employer feels like it's because of his own negligence. He can still recover as long as it happened on the job, and it's no-fault insurance. So there's no question, again, as to whether or not the employee was, generally whether they were negligent and whether that contributed to their own injury. Now, in addition to these premiums, as I mentioned before, an employer, if they truly are an employer, if it's a true employee-employer relationship, you also have to pay, in addition to these premiums, your Social Security and Medicare, otherwise known as FICA taxes, on top of the employee's wages, on top of whatever you withdraw out of their paycheck to pay it. You have to match it, and then unemployment compensation. So this becomes an issue in workers' comp cases, whether the person was actually an employee or not, or whether they were a mere independent contractor. So this is just another reason why that category matters so much. And going back to that lesson, that regardless of what you call yourselves, if a court decides that your relationship was not that, you can call yourselves an independent contractor, but if a court finds that your relationship was actually that of employer-employee or the so-called master-servant relationship, then they will transform your relationship into one in which now you may owe workers' comp payments for that person that you thought was an independent contractor, because that's not how you were actually treating them. So this is a case that just illustrates a situation where they have a bunch of independent contractors and I'll let you pause that and read it. But this just shows you an example of what happens and why this is so consequential, such a consequential categorization in terms of the workers' comp relationship. Okay, and that concludes our brief overview of workers' comp.